Thank you, Mr. Chief Justice, House managers, and staff, members of the Senate, the Majority Leader, and the Minority Leader. At the beginning of these proceedings on January 16, the Chief Justice administered the oath of office to the members of this body, and then again on Tuesday. In doing so, the Chief Justice was honoring the words of our Constitution, Article 1, Section 3. We all know the first sentence of that article by heart. The Senate shall have the sole power to try all impeachments. But then the constitutional text goes on to say this: when sitting for that purpose, they shall be on earth oath or affirmation. That oath or affirmation in turn requires each member of the Senate to do impartial justice. Now, this constitutionally administered oath or affirmation has been given in every proceeding in this body since 1798. Indeed, to signify the importance of the occasion, the Senate's more recent traditions call for you, as you did, to sign the book. And that book is not simply part of the record, it's entrusted to the National Archives. In contrast, members of the House of Representatives do not take an oath in connection with impeachment. The framers of our Constitution well knew when an oath or affirmation should be required. The Senate, yes. The House, no. And thus, each member of the world's greatest deliberative body now has special, indeed unique, duties and obligations. Duties imposed under our founding document. During the Clinton impeachment trial 21 years ago in this chamber, the Chief Justice of the United States ruled in response to an objection that was interposed by Senator Tom Harkin of Iowa. The senators are not sitting as jurors, Senator Harkin noted. And the Chief Justice agreed with that proposition. Rather, the Senate is a court. In fact, history teaches us that for literally decades, this body was referred to in this context as the High Court of Impeachment. So we're not in a legislative chamber during these proceedings. We're in a tribunal. We're in court. In Federalist 78, Alexander Hamilton, who's been quoted frequently in these proceedings, but in Federalist 78, he was describing the role of courts, your role. And in doing so, he distinguished between what he called the exercise of judgment, on the one hand, which is what courts do, and the exercise of will or policy preferences, if you will. On the other hand, that's what legislative bodies do. According to Hamilton, courts were to be, in his word, impartial. There's that word again. And you know, that's a daunting task for judges struggling to do the right thing, to be impartial, equal justice under law. It's certainly hard in life to be impartial. In politics, it's not even asked of one to be impartial. But that's the task that the Constitution chose to impose upon each of you. And significantly, in this particular juncture in America's history, the Senate is being called to sit as the High Court of Impeachment all too frequently. Indeed, we are living in what I think can aptly be described as the age of impeachment. In the House, resolution after resolution, month after month, has called for the president's impeachment. How did we get here? With presidential impeachment invoked frequently in its inherently destabilizing as well as acrimonious way. Briefly told, the story begins 42 years ago. In the wake of the long national nightmare of Watergate, Congress and President Jimmy Carter collaboratively ushered in a new chapter in America's constitutional history. Together, in full agreement, they enacted the Independent Counsel provisions of the Ethics in Government Act of 1978. But the new chapter was not simply the age of independent counsels. It became, unbeknownst to the American people, the age of impeachment. During my service in the Reagan administration as counselor and chief of staff to Attorney General William French Smith, the Justice Department took the position that, however well-intentioned, the independent counsel provisions were unconstitutional. Why? In the view of the department, those provisions intruded into the rightful domain and prerogative of the executive branch, of the presidency. The Justice Department's position was eventually rejected by the Supreme Court, but most importantly, in helping us understand this new era in our country's history, Justice Antonin Scalia was in deep dissent. Among his stinging criticisms of that law, Justice Scalia wrote this: "The context of this statute is acrid with the smell of threatened impeachment." Impeachment. Justice Scalia echoed the criticism of the court in which I was serving at the time, the District of Columbia Circuit, which had actually struck down the law as unconstitutional, and a very impressive opinion by renowned Judge Lawrence Silberman. Why? Why would Justice Scalia refer to impeachment? This was a reform measure. There would be no more Saturday night massacres, the firing of Special Prosecutor, as he was called, Archibald Cox, by President Nixon. Government would now be better, more honest, greater accountability. And the independent counsel would be protected. But the word impeachment haunts that dissenting opinion, and it's not hard to discover why. Because the statute, by its terms, expressly directed the independent counsel to become, in effect, an agent of the House of Representatives. And to what end? To report to the House of Representatives when a very low threshold of information was received that an impeachable offense left undefined may have been committed. To paraphrase President Clinton's very able counsel at the time, Bernie Nussbaum, this statute is a dagger aimed at the heart of the presidency. President Clinton nonetheless signed the reauthorized measure into law, and the nation then went through the long process known as Whitewater, resulting in the findings by the office which I led, the Office of Independent Counsel, and a written report to the House of Representatives. That referral to Congress was stipulated in the Ethics in Government Act of 1978. To put it mildly, Democrats were very upset about what had happened. They then joined Republicans across the aisle, who, for their part, had been outraged by an earlier independent counsel investigation, that of a very distinguished former judge, Lawrence Walsh. During the Reagan administration, Judge Walsh's investigation of what became known to the country as Iran-Contra spawned enormous criticism on the Republican side of the aisle, both as to the investigation itself, but also as to the statute. The acrimony surrounding Iran-Contra, and then the impeachment and the trial, and President Clinton's acquittal by this body led inexorably to the end of the Independent Counsel era. Enough was enough. And living through that wildly controversial 21-year bold experiment with the Independent Counsel statute, Congress, in a bipartisan way, had a change of heart.